Two commercial appeals we have filed today. Order is passed on Saturday. There is a dissolution of the firm. Section 9 application was filed by us as also the other partners. Now the court, my lords, we had sought an injunction. I am the owner of the property. We had sought an injunction that the respondent's partner should not interfere in the property's possession. It's a wedding hall and a wedding venue, my lords. And also pre-wedding photos are taken studio. Now the court below, my lords, instead of looking into the dissolution, once I issue a dissolution notice under the Partnership Act, the dissolution takes place automatically. Court says instead of granting an injunction, both of you shall continue the business. Because of that, they are coming and interfering and they start to book venue. So, my lords, we have challenged that order. There is some urgency in the matter because even the police are coming and giving them possession.
7th will do. Early.
My lords, I wanted it at 2:30 today because,
No, not
because the police are trying to putting them in possession of the property. Otherwise, tomorrow, if it's tomorrow, please.
Lords, serial number 98, Lords. Lords, I had made a mention pertaining to this matter to file a memo to be taken up on any other day at 2:30, Lords. Your Lordships indicated that I can move the matter today itself to be taken up at 2:30. Lords, if it is possible at 2:30 today, my lords, may I request. Lords, I'm in your lordship's hands. I fully understand.
To be candid with all of you, lot of
Can I
administrative work to be attended in the second half. So
Can I
second half,
request
please
for-
don't mention today for second half. Tomorrow,
2:30, my lords?
tomorrow,
I'm so grateful, my lords.
tomorrow,
Lords, your lordships may say tomorrow 2:30, my lords, if it comes to.
tomorrow we will start at 2:30.
Lords, so grateful.
You-
Serial number 32, my lordship. Lordship, serial number 32. Pray for 1 week time because I have filed amendment application before the Honorable Single Judge. It is coming on 4th. Therefore, kindly have it next week, my lord. Serial number 32.
Next week will mean 24th of April.
Your lordships.
Serial
Your
number
Lordship.
87, serial number 87. I seek 1 week time to comply. Serial number 87, read the bill.
Writ appeal, court fee not paid. So we'll just pass the order in all matters. 83, 84. So office of them to be removed within 4 weeks, failing which. Then 85, 86, 87. 3 weeks. 88 also 3 weeks. 890 also 3 weeks. Right?
Your lordships, we have filed a commercial appeal.
So 88, 82, 82. The learned away for the petitioner, public appellant, whatever, shall do the needful to pay the process
Your lordships, we filed,
in 1 week.
we filed a commercial appeal. We're seeking for it to be listed tomorrow. The impugned order is by the commercial court. The matter stands listed day after before the commercial court. So if
Will
the
this-
appeal may not, if it is not allowed tomorrow, our appeal will become infructuous.
Why?
Because it can be finally disposed of day after tomorrow before the commercial court. It stands
So
to be
this is
finally.
against interim order.
Yes, this is against the impugned order is an interim order. We have filed an appeal against the interim order. So if it may be kindly listed tomorrow, so the appeal will.
Tomorrow.
Oblige.
Your lord, serial number 79, we seek 1 week's time, your lord. Senior
Okay.
has a serial number 79, writ
17.
appeal.
It will go after vacation.
Your lord, it is a little urgent matter. Senior is simultaneously stuck at Supreme Court. Senior is stuck at Supreme Court. That's why 1 week's time, your lord.
25th of April.
Serial number 44, Your Lordship.
40.
44. Partially, we have complied the order. And they have filed a memo of a calculation complaint. We will comply by 2 weeks and file compliance affidavit.
Then let it, who is for the petition?
I have informed the petition complainant.
Come with him tomorrow at 11.
You-
Complied with.
You have partially complied. They have filed a memo of calculation.
His presence will be necessary.
I will wait.
Inform him tomorrow at 11.
I will already informed. I will by 2 weeks we will comply with the remaining payment of.
Let him be here personally.
I will wait.
My lord,
Tomorrow at 2:30.
my lord, serial number 13, my lord, 13. May be taken up after vacations. Serial number 13, I appear for the appellant.
30.
13, man, 13. I've informed the other side.
at the request of learned appellant, stand over to say 17th of June.
Please, great.
That's serial number, I'm sorry, Sam. Serial number 68, my lords. My lords had directed the registry to list it not under the orders category. But my lords, again, they have listed it under the orders category.
Doesn't matter. What is?
I wanted to take it up at 2:30, my lords, but I understand that you, my lords may have it
We don't
tomorrow at
know whether
2:30.
we are,
Madam, serial number
you are
27.
sitting half an hour. Huh?
Please, my lords.
Serial number 27, madam. Ready for 2 weeks time, madam.
Bill number?
I am 27, 27.
47. What do you want?
My lords may have it tomorrow at 2:30, my lords. 68,
All right, tomorrow.
2:30 minutes. Grateful.
My lords, may I, in that
But you won't
matter, my
notice.
lords,
My lords,
You won't notice.
no, my lords, the order has to be complied with, my lords. It's a matter which is pending from 2004.
Other side is appearing.
Other side is also, notice has been served, my lords, the government has to appear.
lords, I appear in that matter. Lords, it may be taken up after a week's time, my lords.
All right, after a week.
My lords,
Obliged.
my lords may have it tomorrow at 2:30. We'll explain you the urgency.
Then without instruction, same
Lords,
thing.
it's been 2 dates, they're without instructions after my lord's order.
8. At that time, we take instruction.
At 2:30, my lords,
8:32.
grateful.
Madam, serial number 27.
Matter, commercial appeal has been filed against the one order, interim order, and they go for the procedure for the non-compliance of interim order. We already complied the interim order, and then 8/4 has been given a day for the contempt proceeding, Your Honor. In the contempt proceeding, making as a inquiry, posted for the inquiry, I filed the
8.
for tomorrow. Your Honor. I already complied the office objection.
Tomorrow not possible. 8.
Day after.
8.
Serial number 27, madam. Serial number 27, madam. Ready for 2 weeks time, madam.
No. Let it be called out. PIL of 20.
I for the respond number 7, madam. I have to file the objection.
Maybe let it be.
I
let it
inform the other council also.
Serial.
Without consent of the court, you can't inform the other side, I am seeking time, and the court will be granted.
I am sorry to mention, 4th of April, I will not be in station. Therefore, any date, either 3rd or next date, any date.
7.
Hello, serial number 100.
7.
Senior is not well, so
7th.
raise for 1 week of time.
Serial number
100.
100. Senior is not well. Day after tomorrow at 2:30. $28. Pardon? Petitioner is up, no objection, appellant is no objection. You have filed in. Can it go after? Stand over to 16th of June. Thank you. Interim order operating in the, already operating, shall continue to operate till the next.
Any other mention through weeks, sir? Will be dated. So, with kind permission, contempt matters?
7th.
Yes. Yes, anybody is mentioned?
Serial number 1.
Arjun Kumar, yes.
My lord, serial number 62, 2 weeks time may be granted, my lord.
60?
66, my lord.
66.
The copy has been already served to the council for the complaint, my lord.
It will go after summer vacation.
Okay, my
10th
lord.
of-
Okay, my
10th
lord.
of- Now copy of the compliance.
Already served, my lordship.
No, to the council of the other side. Council of the other side is here, he complains that copy is not so. He'll serve. Copy of the stand over to 10/6. In the meantime, copy of the petition shall be served to the council.
Much obliged, my lord.
Yes.
Copy serve ಮಾಡಿದೆ.
Yes, what is this? Number 1?
Number 1.
Okay, the complaint, made an ask of stay against the issue of sales certificate.
10th of June ಅಲ್ಲ?
Despite that,
Thanks.
they issued a notice for the non-certificate purchaser to remove the hospital equipment in premises therein. So that has been stayed by the Honorable Court. Now the non-certificate purchaser continuously executing the position in collision with the management. I issued the notice to our manager.
Very- It is an interim order.
Because in the running hospital,
Huh?
Ramalajity hospital is there.
Hmm.
We have the part here, more than 100 crores. The outstanding liability is equal to 1.36 crores, out of which we have paid 44 lakhs.
But this order in your favor.
Otherwise, we have,
What is the contempt?
and they should not dispose of, they should not issue the sales certificate. That is, despite that, the hospital was under the rapid key. The minimum is investment of medical equipment about 4 to 5 crores. The prospective purchaser is the collusion with the bank.
Take your mic. Take mic.
The prospective purchaser in collusion with the banks, they wanted to remove the medical equipment from the hospital. We have got a collateral security deposit to before the bank about running to about 30 to 40 crores. Despite that, the person who has backed out in the earlier action, the action has been confirmed in his name. Now the prospective purchaser is attempting to remove the medical equipment and they wanted to take the possession of the property in collusion with the bank management, despite serving the notice to the bank and interim order also.
So that prospective purchaser is not a party.
Here, they have made an impeding application before the court below also.
No, here you are alleging contempt against the bank or prospective purchaser?
No, our collateral security is lying with the bank about 100 crores. Our liability is about 96 lakhs. We have deposited 44 lakhs for them also. Because the only thing is, the manager has assisted the prospective purchaser in removing the medical equipment installed in the hospital.
Go before learn a single judge. What is petition is pending?
That interim stay order is also there. Despite that, they are interfering.
Notice. 25th of April.
My lord, still number 2, the award of the labor court, my lord, which was confirmed by the honorable court and the honorable Supreme Court has not been complied with, my lord. The termination was in the year 2012. The direction to reinstate him was during 2017, my lord. In spite of this, they have not reinstated or they have not paid the wages, my lord.
Notice returnable on. Say, first, when shall we give? 29th of April.
Number 3.
For complaint, the honorable single judge has issued a direction for consider the representative.
It's returnable on 4th June.
Already it is education institution. Already 29 students have been admission has been taken place.
29th of?
29 students has been admission has been the board has PUC board has been issued a direction for cancellation of license. There is a due to 4 years of
What do you notice?
by within April
April
2nd week, 3rd week.
23rd April.
Still number 4. To Supreme.
Notice 4th June.
Still number 5. 5. Supreme.
4th June.
Six.
Now,
kindly see. Here, my lord, the non-compliance of the order dated 19/11/2021, wherein the excessive stamp duty they have.
5th June.
But in addition to that, I may be permitted to serve notice by way of by hand service. And
Service of
particular date may
notice by
fix
hand
because
delivery
the
is permitted.
Honorable Supreme Court has dismissed the special petition filed by the other side.
5th of June.
Not so. The Honorable Single Judge directed the Tahsildar to remove the obstruction present in the path road adjoining my agriculture.
3rd of June. Notice, 3rd June.
Number 8.
Your Lordship, in this case, I beg to appear for the petitioner. The respondent number 2 has acknowledged that there is an illegal construction and yet they have not taken any action. To which I made a representation to the respondent number 2 to please take action. And that has not been taken so far. That's why I'm before the Lordship. Lordship, the respondent number 2, in fact, has actually issued 2 notices. First, in the month of January 2024, that is in Annexure A. And then after 8 months, they have again issued the same notice, seeking documents to verify that your building is actually in compliance with the prevailing laws. Over this period, Your Lordship, the respondent number 3 and 4, being the building owners, they have actually proceeded to enjoy the business. It's a marriage hall, conventional hall. My prayer is to just seek a direction for them to act on my representation. That's all, Your Lordship.
Where you admitted? You are saying that they were admitted. It's already, it's Sabha Mandapa, what is it? So page 26 already notice is issued.
Lordship.
Page 26. The Panchayat Development Officer.
Please, they have issued the notice and then they've still not taken any action. And then, Your Lordship, in the month of October, 2 months later to that notice, I filed my representation and there's no response to that representation. They're still right now as I make my submission, they're still conducting their business illegally over an agricultural land without getting any proper sanctions or licenses.
This village is, which is the village?
Lordship?
Which is the village? Village. Chandana.
This is Agalakuppe village.
Chandana. Asahalli. Chandana Asahalli.
Lordship, this is in Agalakuppe village, Gram Panchayati office.
No. Chandana Asa village under Agalakuppe Gram Panchayat. That's
No, Lordship, actually this actually the concern of an illegal building was raised by the villagers of Chanda Hosanahalli village.
correct.
And then upon that, they have acted on it.
And how far this Chandana Anna Asale village from Bangalore?
This is from Bangalore rural, Your Lordship.
How far?
No, Bangalore rural, Nelmangla Taluk, Nelmangla district.
How far? Distance.
Your Lordship,
Distance from Bangalore to this Sandanahallas,
just 40, 50 kilometers, 40, 50 kilometers.
40 kilometers. So how you are concerned with that village? You are the resident of Bangalore.
It is Bangalore rural district, that is.
How you are concerned there?
Your Lordship, I am a representative of the Karnataka Lanchamukta Vedike, that is an anti-corruption forum.
Styling as public interest petition. Styling this, in this petition, styled as public interest petition, the following two prayers are advanced. So page 19. Roman small 1, Roman small 2, bracketed first. The petitioner, who is the resident of the city of Bengaluru, seeks to complain before the court by filing this petition. Inter-alia that private respondent 3 and 4 have constructed and have been operating Maruti Mall Village Hall on agricultural land bearing survey numbers 7/4 and 7/5 in the Chandana Ansa Hosa Halli village, which has covered built-up area of approximately 10,000 square feet. It is the case that this construction is put up
Lordship,
without
one small submission.
taking necessary land conversion under section 95 of the Karnataka Land Revenue Act 1964. And the change of purpose is not effected in respect of the land in question. Yes.
Lordship, my representation starts from page number 34. Chanda Hosanahalli villages representation is different. Based on their oral complaint, they have acted. But still now there is no action being taken against the respondent number 2 and 3 and 4. But my representation starts from page number 34.
It is the case of the petitioner that on 14/12/24, the villagers of the village have lodged complaint with respondent 2. That's the Panchayat Development Officer. It is the allegation that acting in collusion with the private respondents, the side authority has not been taking any action. There are 280 reasons why this court is not inclined to entertain the present public interest petition. Firstly, the petitioner is admittedly a resident of city of Bengaluru, and the illegal construction has happened according to the petitioner in a village far away from city of Bengaluru in the rural area. This apart from it is evident from the record of the petition itself that pursuant to the complaint dated 14/12/23 by the villagers mentioned above, the Taluka Panchayat Development Officer has already issued notice dated 22/8/24 asking the respondents to make their stand clear with necessary documents, further providing that failing which the necessary action under the Panchayat Raj Act 1993 will ensue ENSU posted. In the aforesaid view, no case is made out to.
Your Lordship, I may be permitted to withdraw the petition. I may be permitted to withdraw the petition, Your Lordship.
Before order is complete.
Your Lordship, I was of the view that the petition would have been allowed.
Believing that we are rejecting the petition.
Your Lordship, the petitioner is a convener of the Anti-Corruption Bureau all over the Karnataka. He's a elected.
What do you want? You want to withdraw the petition or you want the completion of the order?
Lordship, a date may be given tomorrow.
No.
I will seek instructions from my client.
No, right now. Either we complete the order, you wait till the order is completed.
Lordship, the matter may be passed over. I'll seek instructions
No,
right now.
sir. How can it be? So you're withdrawing or?
I will withdraw it with the
Learned
liberty to
advocate,
file.
After some amount of submissions, learned advocate for the petitioner, Mrs. So-and-so, seeks permission to withdraw the original petition, dismissed as withdrawn.
Grateful.
I appear for the petitioners, Lord.
Yes.
So this is a public interest litigation, Lord,
Mm.
challenging, Lord, the fair increase, Lord. But the representation, Lord, made by the first respondent was that, Lord, they'll increase the fares by only 15 to 25%. But in fact, they have ended up, Lord, increasing it by about 71%, Lord.
Fair is increased for what?
Yes, Lord. The Lordship may kindly see, Lord, in the writ petition itself, I have mentioned, Lord, at page 16, Lord. Page 12, para 16, Lord. Arbitrary fare hike in 2025. In February 2025.
Fair for what? Fair for filing public interest litigation?
Yes, Lord. But the reason is this, Lord. But what was represented to the.
Now the public interest petition has become costly.
No, may I just point out a few facts, Lord? Your Lordship may kindly see.
Fair for what, Mr. Counsel?
No, there was a public agitation also on this aspect.
Fair is increased in respect of what?
Fair is in respect of, Lord, the metro service, Lord.
Metro services.
Yes, Lord.
So what court can do in that?
No, Lord, when there's a representation given, made by the first respondent that they will increase the fare only by 15 to 25%. Lord, they cannot go back on that and then increase it by 71%. It amounts to promissory estoppel, Lord. Lord, there are two decisions which I am relying on. One is doctrine of legitimate expectation. The other one is promissory estoppel, Lord. Annexure B may kindly be seen, Lord. Annexure B, which is on page 36, Lord. Page 36 may kindly be seen, Lord. Page 36, Lord. The very first line below the heading, Lord, BMRCL is considering a fare increase of 15 to 25%, marking the first hike since the last revision of 10 to 15% in 2017. So, Lord, there's a representation by the first respondent that the fare hike would only be around 25% maximum. Now, what they have achieved is now 71%, Lord, 3 times that much, Lord. And Lord, this is, Lord, contrary to promissory estoppel, Lord, and Lord, doctrine of legitimate expectation, Lord. Giving out 2 decisions of the apex court, Lord. And also, there's another aspect to this case, Lord. Section 33 of the Act may kindly be seen, Lord. Section 33, which I have extracted, Lord, in page. Page 18, Lord. Page 18. Page 18, para 22, not on page 18. A fixation of fare for carriage of passengers. The Metro Railway Administration shall from time to time on the recommendations made to it by the Fare Fixation Committee constituted under section 12, subsection 1, subsection 34, fix for the carriage of passengers fare for traveling from one station to another of the metro station. Page 18. No, they have fixed the fares, not stage wise, not instead of not station to station. Under section 33, they were required to fix the fares from station to station, whereas they have fixed it not stage wise, not first stage, second stage, third stage, which covers the two or three stations at not in one stage, not.
Jurisdiction of this court.
May I just point out two decisions of the apex court on doctrine of legitimate expectation and promissory estoppel.
Your appeal.
BMRCL has not been, notice has not yet been issued to BMRCL. It not be promissory estoppel applies to government or state in whichever capacity tax. Then next page, the para 2. The principle of promissory estoppel may be stated thus: where one party has by its words or conduct made to the other a clear and unequivocal promise which is intended to create legal relations or affect a legal relationship to arise in the future, knowing or intending that it would be acted upon by the other party to whom the promise is made, and it is in fact so acted upon by the other party, the promise would be binding on the party making it, and he would not be entitled to go back on it. Right?
Yes.
And the relevant portion is on page 438.
Page
438.
highlight. Okay.
Yeah, highlighted portion. The doctrine of promissory estoppel has also been applied against the government, and the defense based on executive necessity has been categorically negative. It is remarkable that as far back as 1880, long before the doctrine of promissory estoppel was formulated by Denning J. in England, a division bench of 2 English judges in Calcutta High Court applied the doctrine of promissory estoppel and recognized a cause of action founded upon it in the Ganges Manufacturing Company versus Surajmal. The doctrine of promissory estoppel was also applied against the government in a case subsequently decided by the Bombay High Court in Municipal Corporation of Bombay versus the State of Secretary of State. Then this is insofar as promissory estoppel is concerned. Your Lordship may take the second judgment, which is 2020 SEC online 968, para 34. Another difference between the doctrines of promissory estoppel and legitimate expectation under English law is that latter can constitute a cause of action. The scope of the doctrine of legitimate expectation is wider than promissory estoppel because it not only takes into consideration a promise made by a public body, but also official practice as well. Your Lordship, I can, at a 34, mark portion.
39 also mark.
Yes. However, no such requirement is present under the doctrine of legitimate expectation. In our view, these things matter in public law, even though they might not found an estoppel or actionable misrepresentation in private law, because they go to fairness, and through fairness to possible abuse of power, to disregard the legitimate expectation, because no concrete detriment can be shown, would be to place the weakest in society at a particular disadvantage. Then next page, para 35. The basis of doctrine of legitimate expectation in public law is premised on the principles of fairness and non-arbitrariness surrounding the conduct of public authorities. This is not to suggest that the doctrine of promissory estoppel has no application in circumstances when a state entity has entered into a private contract with another party. Under Indian law, at times the expression legitimate expectation and promissory are used interchangeably. But that is not a correct usage because legitimate expectation is a concept much broader in scope than promissory estoppel. That is in paragraph 36, Lord, of the judgment. Now here, Lord, there's a representation made by the first respondent that it will not increase the rate beyond 15 to 25%, whereas it has increased it by 71%. It was 100%, it is reduced to 71%. Therefore, when not a representation is made by the first respondent that it will not exceed 25%, to go beyond that, is contrary to law, and it is beyond promissory estoppel and the principles of promissory estoppel as well as principles of legitimate expectation come into play, and therefore, the first respondent is liable to reduce the rate to 25% increase. We are not saying that you don't increase. Right, they are entitled to increase, but it shall not be beyond.
Heard learned advocate Mr. So-and-so, the petitioner, and learned additional government advocate Srimati Nilofer Akbar, who appeared to assist the court upon service of the copy of the petition in advance. Full stop. Invoking the jurisdiction of this court under Article 226 of the Constitution, the present public interest petition is filed by three petitioners who happens to be an automobile engineer, holder of MSc degree in microbiology and in electronics and communication, and who is an electronics and communication engineer, respectively. Engineer employed in a private firm, respectively. Full stop. The prayers advanced by the petitioners are firstly to direct respondent number 1. That's the Bangalore Metro Rail Corporation Limited to reassess the fare fixation after obtaining a report on the fare increase from a committee appointed as per the directions of this court. The second prayer is to direct the Bangalore Metro Rail Corporation Limited, indicated BMRCL, not to exceed the fare beyond 25% of the fares prevailing prior to the revision, which is effected on 8 to 25, as initially proposed by the BMRCL. It is further prayed to direct the respondent number 1 to adhere to the station-to-station fare fixation mechanism. Station-to-station fare fixation mechanism as mandated under Section 33 of the Metro Railways Operation and Maintenance Act 2002, and to rectify the alleged inconsistencies in fare determination. The prayer is also made to direct the BMRCL to ensure the compliance Section 23 of the Metro Railways Operation and Maintenance Act 2002 by displaying fare tables at all metro stations in different languages. The blank of submission of the petitioner in seeking the grant of the aforesaid prayer is that earlier the representation was made to BMRCL not to increase the existing fares beyond 25%. Full stop. In this regard, learned advocate for the
Page 36.
relied on the, what is this newspaper report?
No, this is a press release, not
Press release,
press release.
whereby it is indicated that the BM RCL was considering the fare increase of 15 to 25% since the last revision of 10 to 15% in 2017. It was submitted that now the increase in the fare has gone up to 71%, which is almost 100%. It was therefore submitted that the fare increase by the BMRCL is liable to be frowned upon for two reasons. Paragraph. Firstly, it was submitted by learned advocate for the petitioner that it is in breach of the principle of promissory estoppel. It was submitted that, it was next submitted that the BMRCL has also acted in contravention of doctrine of legitimate expectation in increased fare. Full stop. The concept of promissory estoppel was sought to be explained by learned advocate of petitioner by placing reliance on the decision of the Supreme Court in Messrs. Motilal Padampat, PADAM, PAT, Padampat Sugar Mills Company Limited versus State of Uttar Pradesh, into bracket 1979, 2 SCC 409, in particular, highlighting that where one party has by his words or conduct made to other party an unequivocal promise, the state party is bound to act upon accordingly. Full stop. Another decision also of the apex court in state of Jharkhand versus Brahmaputra Metallics Limited, Ranchi, which was civil appeal numbers 3860-3862 of 2020, arising out of SLP Interpret C numbers 14156-14158 of 2020, decided on 1st December 2022, was pressed into service to submit that the doctrine of legitimate expectation is even wider than the concept of promissory estoppel, and that the authorities are expected to honor their own statements. Full stop. As far as the present paragraph, subject matter of hiking the matter of head is concerned, the provisions of the same is done. The section 33 of the Metro Railways into bracket Operation and Maintenance bracket or Act 2002. Section 33 of the Act reads as under page 18 per 4. Full stop. Thus, it is evident from the aforesaid section that the Metro Railway Administration is empowered to fix the fares from time to time. Also, the task is done by the Fare Fixation Committee, constituted under section 12, under section 34, into 12 into 1. The Act for the carriage of passengers, fare for traveling from one station to another, and for such purposes. It is provided that the fare shall be fixed only upon It is provided, the proviso contemplates that the railway administration may fix the fare under this section, even without recommendation of the fare fixation committee. On the initial, not even, on the initial opening of the metro railway. Full stop. The fare fixation by the railway administration for operation of the metro rails is क्या लिखा? The fare is a statutory exercise in the sense that it is the fare fixation committee constituted under the law is entrusted with the task. Full stop. Fare fixation is an expert exercise where host of the considerations would have a play, including technical and financial considerations. Full stop. It is not the domain of the court to delve into such aspects which are to be better considered by the fare fixation committee constituted under the statute. Full stop. The court would not interject in such decisions unless, full stop, a statutory infringement is indicated. Full stop. The submission of submissions paragraph. The submissions about the breach of promissory estoppel or negation of doctrine of legitimate expectation hardly have any legs to stand. Full stop. There was no estoppel, there was no promise not to, there was no promise at any point of time not to increase the fare. Full stop. The concept of legitimate expectation cannot be invoked in abstract. Full stop. Nor the circumstances of the case suggest that there is any breach of legitimate expectation, merely because the petitioners had made a representation that the fare should not be increased beyond a particular level, and that has not been done. Full stop. It is not possible to conclude at all that the respondents are the external party respondent is liable to be treated as vitiated on the count of breach of promissory estoppel or the legitimate expectation. These principles does not apply in the effects of the case. Full stop. No case is made out to grant any relief to the petitioner. Full stop. The public interest petition and the prayers made in are thoroughly misconceived to be considered by the court. The petition is dismissed.
Number 10, it's a green bench matter, Mr. Srinivas.
What is?
Petitioner, my lord, is claiming. Kindly, my lord, it's a patta land. It is a patta land.
Methods of pricing or method of fare fixation is not the function of the court. I said, which man?
Petitioner was granted mining lease and as per annexure A, page 28. It's a patta land. But no mining lease was executed. Only they executed this lease deed, but it was not registered. And this the petitioner had approached this on court. Kindly turn to page 115. At page annexure N1. Since the lease deed was not registered in the name of the petitioner, he has approached the Sound Court for a direction, seeking a direction to the state government for execution of the lease deed, registered lease deed. And this Honorable Court has directed the state government, para 3 of the judgment 117, since the same has not been considered, we are of the view that it is for the Director Department of Mines Geology to consider the presentation wide annexure U dated so and so within 8 weeks from the date of.
The time period lapsed.
Yes, Millard. Meanwhile, Millard, sorry.
So it is a statutory time period for execution of lease deed.
No, Millard, it can be, it is for the competent authority to, it can extend to, 6 months time was there as per
You are
Rule
showing-
31. Rule 31. 6 months was time there. It can be extended from
But
time
the
to time.
time that is granted lapse on the part of the petitioner as can be seen. My lord, as per the orders of the government, my lord, page 216.
Millard, I will come to that. First, there are two aspects of the matter. One is non-execution of lease deed in favor of the petitioner. And another is for not obtaining the conversion order for under section 95, Millard, it was not commenced the mining operation, so it was lapsed. And there are two aspects. Now, now kindly turn annexure. Just we come to. It
Page?
was lapsed because
Which-
non-operation of the mine for a period of 2 years.
Under which provision? will lapse?
123 page, page annexure Q. Provision is Millard, what section 28, Rule 28 of the Act. Kindly turn to page 123, annexure Q.
What is that?
Annexure Q, page 123, wherein this order was made and converted. It is the English version, we'll get it. Page 126. In pursuance of the above the mining lease so and so, on the basis of the audit report, any of the mining lease is inactive for more than 2 years. Hence, on the basis of the powers conferred on para 9 of the notification so and so, under Rule 28(1) of the Mineral Consent Rules, QL number so and so is ordered as lapsed one. In this mining area, a kind of mining activities are prohibited, against which I filed a revision petition at page 132, page 132, annexure S. We filed a at page 132, and the English version is 33, 136. We filed, this petitioner filed a revision petition before the state government. State government, and it was pending for nearly 8 years. This was petition, this petition was filed on to 34 to April to 2014. And now kindly turn to page annexure. Annexure Y at 215. 215. This was the order passed by the state government, again rejecting the state, treating the main of the petition as the lease lapsed one. That was the order passed on 30th November 2022, after lapse of nearly more than 8 years. In this, kindly turn to page 215. 215. Annexure Y.
What is it?
That is the order of the state government for having treated the petitioner mine as lapsed one. In this, it has highlighted, everything is considered, it is taken on record, but no file, reasonable, no orders, the reasoning is given. Just it has rejected the claim of the petitioner. Now, kindly turn to page 216, wherein it is referred few facts. It will start from 2.1, page 215. The mining lease bearing number so and so granted to petitioner, extract of limestone in survey number so and so for a period of 20 years, effective from 18/7/2003. The duration of the lease was 17/7/23. The said mining lease was granted in a patta land. According to the audit report, spot inspection report, Deputy Commissioner Belagavi, it is found that applicant was not conducted mining activities and the mining lease was been kept inactive for the period so and so. In the meanwhile, they made a representation dated 17/2/2012 to re-execute the mining lease. The same has not been considered by the Department of Geology, Mines and Geology. Being aggrieved by this, the applicant filed a writ petition for 45,774 per 2013 before this Honorable Court. And this Honorable Court has, on perusal of annexure, it is clear that as the petitioner herein furnishing the bank guarantee in respect of mining lease so and so, has requested the director to re-execute the mining lease. Since the same has not been considered, we are of the view that it is for the director, Department of Mines, to consider the representation of the petitioner dated so and so within a period of 8 weeks. Therefore, in view of the same, Deputy Director Belagavi issued a so-cast notice dated 28/5/2013 as why the lease shall not be declared as lapsed on lapsed under rule 28(1) of the MCR rules. Next, thus, being the position, the Department of Mines and Geology by exercising the rule 28(1) of the mineral concession rules, which is confirmed by a wide notification dated M5 dated 27/5/1995 has declared the mining lease of the applicant as lapsed on 24/4/2014. As per the notification dated 27/9/1995, CL number so and so, the Director, Department of Mines has delegated with various powers of state government. At serial number 9 of the said notification, following powers are delegated. A, declaration of mining lease is lapsed under Rule 28 of the MCR rules. Disposal of application under Rule 28(2) or under Rule 28(4) of the MCR rules. Disposal of applications under Rule 28A by an order under Rule 28(3) of the MCR rules. The applicant has filed application for restoration of lease on 4/6/2014. In terms of Rule 28A1, it is admitted that you have filed application on 2/12/2014. An endorsement has been granted by the Director of Department of stating that the lease of the applicant has been declared as lapsed. There are no provision in the rules for restoring the lease. Next, para 2.110, 2.10. The provisions of minerals other than the so and so are with effect from rules have come into effect from 4/3/2016. The provisions of Rule 55 can be employed for the purpose of restoring the lease. The delegated powers of such were exercised by the director are not available,
Yes.
and the state government
Rule 28.
may consider exercise powers for the
Third learned advocate, Mr. For the petitioner and learned additional government advocate, upon service of copy of the petition in advance. The competent authority by order dated 30th November 2022 treated the mining lease number 2412 for mining of limestone in the area of 10 acres in 4 guntas at Avaradi village, Gokak Taluka, Belgaum district, belonging to petitioner. in view of Rule 20 of the
My lord, 28-1, my lord.
why it is mentioned 227 Rule 20, page 227. Lapse
It's lapsed, my lord.
under 20 of which rule? This is different rule.
28-1 of the minor concession rules 1960.
20. Under Rule 20.
28.
No, 20 likha is. So there must be some significance of 20 also. 20 is wrongly treated.
28-1 of the
20 is wrongly stated. 20 of the mineral other than mineral concession 16. वो कहाँ है? 2016 rule. Mineral concession rules of 2016.
Correct. Well, as per amended rule 28A, it can be revived for twice, my lord. But in my case, so far nothing has been done. Or not even once it is not revived. It can be revived for twice as per it is mentioned in this order also at page 223.
Under Rule 20 of the
Yes.
minerals interpret other than atomic and hydrocarbons, energy, minerals, and to bracket over concession rules 2016. Full stop. It is to be noted that the said rule, it is to be noted at this stage itself that said rule deals with lapsing of mining lease. Under section 20, under Rule 20 of the mineral rules 2016. Paragraph. The said order was taken by the petitioner before the revision authority by filing revision application number 13. Revision application which was dismissed by order dated 13th of March 2023. It is this order which is sought to be challenged by filing the present petition. Full stop. The additional prayer is made
Mine's tribunal order
to direct
at
the
page Z.
respondent
231.
authority to re-execute the mining lease deed in favor of the petitioner. Full stop. The facts of the case go to show that the petitioner as revisionist was granted mining lease for a period of 20 years with effect from 18/7/2003 for extraction of limestone mineral in the area of 4.06 hectares at Avaradi village. It appears that the mining operations were scheduled to commence on from the month of November 2003. Full stop. At a later stage, the lease deed was not re-executed by the authorities in favor of the petitioner. Since the other leaseholders were allowed the execution of the lease deed, the petitioner made a representation. Paragraph. The who is DMG, Director of Mineral?
Director of Mines and Minerals. Director of Mines and Geology, my lord. Mines and Geology. Director of Mines and Geology.
Director of the indirect, it appears that paragraph, the Director of Mines and Geology issued so cause notice dated 18/10/21 to the petitioner under Rule 26/1 of the Mineral Concession Rules 1960, treating the lease of the petitioners as having lapsed for the reason that the leasehold land was not used for a period of 2 years. Full stop. The reply of the petitioner was considered but was not found satisfactory. Full stop. The competent authority cancelled treated the lease to have elapsed, and the same was confirmed in the revisional proceedings. Full stop. Section 20 of the minerals and debris other than so and so consists under 16, not section rule, reads as under, which is in respect of lapsing of the mining lease. Import the entire rule. It deals with the lapsing of the mining lease, provides in its subsection 1, inter-alia, that where production and dispatch has not commenced within a period of 2 years from the date of execution of the mining lease, or is discontinued for a continuous period of 2 years after commencement of the mining lease, the lease shall lapse. Therefore, the lease granted to a person would lapse in 2 circumstances as provided in the aforesaid rules. Firstly, if the production has not commenced within 2 years from the date of grant of lease, and secondly, during the subsequent periods, if the production activity has been discontinued for a period of 2 years. Full stop. The respondent authority has found that the mining lease of the petitioner was discontinued for 2 years. Therefore, it was treated to have been lapsed. Paragraph. The action is taken under Rule 28(1) of the Mineral Concession Rules 1960. Rule 28, not section, Rule 28 and 1, dealing with the lapsing of lease, contemplates the same thing, that if the production has discontinued for a period of 2 years, the mining lease shall stand to have lapsed. Paragraph.
There, continue, 28A amended. It says it can be revived, proviso says, it can be revived for twice during the period of lease.
28.
Proviso.
Learned, where is that? Learned advocate.
28A.
This is learned advocate
Amended.
for the petitioner submitted that proviso indicated that proviso says that
Provided further that such extension shall not be granted more than twice.
where is that?
I don't
My
have.
lord, it is referred in page 22 to
No, no.
223, my lord.
Show from the, provided that the lessee has failed to make an application within the time
Next, my lord.
stipulated, lease shall lapse. On the contrary,
Next, proviso is the
the shade rule clearly provides in its proviso that if the lessee has failed to make the application within the time stipulated above, the lease shall lapse on expiry of the period of 2 years.
led after 7 para. So it is there.
No, you show from the book, not from the record.
Both to- Oh, my lord, I have amended. Sorry.
The revision authority has observed that the
Amended.
revisionist less petitioner failed to get the mining lease deed registered within the stipulated time. Consequently, although the state, not consequently, it was further observed that although the state government had granted permission for re-execution of the mining lease in favor of the revisionist, the action could not be initiated due to failure on part of the revisionist to produce the NA certificate. full stop. It was further found that despite, a further finding was recorded that despite several notices received by the Director of Minerals and Geology, the NS certificate was not furnished by the petitioner revisionist. The revisionist did not respond even to the notices issued by the competent authority as to why its lease should not have been treated as lapsed. Full stop. Not only that, despite that the revisionist, despite that the petitioner did not respond to these notices as aforesaid, before passing the impugned order, state government conducted even inquiry thoroughly and extended opportunity to the petitioner of hearing on 3/8/2022. Full stop. The explanation of the petitioner was not found satisfactory, and after considering the after considering the evidence and the material record, the revisional authority confirmed the order of lapsing of order dated 30th November 2022, passed by the competent authority, treating the lease of the petitioner to have lapsed. Full stop. For all the aforesaid reasons, not for the order of the competent authority dated 30th November 2022 is a reasoned order. Full stop. The revisional authority applied its mind to the material on record and came to the same conclusion. Full stop. The finding that the petitioner did not continue its mining operations for 2 years is a finding of fact recorded by two authorities concurrently. Full stop. There is no occasion for this court to upset the same in the jurisdiction. Full stop. Paragraph. No error could be booked in the order of regional authority, whereby the lapsing of lease of the petitioner was confirmed. Full stop. The challenge is meritless. The petition is dismissed.
Obliged.
That my submission was my land. It has not been considered properly by both the revision authorities. And it has taken 8 years and have.
What is your submission? What is your submission?
Rule 28A is amended and it says it can be revised, it can be lapsed twice during the period of lease.
It was submitted by learned advocate for the petition that Rule 28
Not
was
in
amended.
here,
and
not
the
even
authorities
once it is revived.
Authorities were empowered to consider the case of the petitioner during the subsistence of lease. Full stop. However, when the authorities have not found the case fit to exercise such a discretion on the material and evidence before it, the court is not inclined to substitute its view. Next. On the operative.
My lord, I need to address my lord, some more time, my lord. Kindly elaborately it has to be discussed, my lord. Both the courts, revision authorities have not considered it.
To be noted that under Rule 20/3, the petitioner was enjoined to file application for setting aside the lapsing within stipulated time with prescribed fee. Full stop. Admittedly, the petitioner has not made this application.
No, since it is a patta land, my lord, it cannot be
Either
auctioned
the
or.
application was made nor the prescribed fee of ₹1 lakh was paid. Was accompanied with the application. Full stop. It could hardly be said, therefore, that the authorities committed any error in rejecting the prayer of the petitioner. Delay.
Appear for
Delay of-
termination without inquiry, my lord.
Delay is there or no?
a delay of 6 days is there. Termination, my lord, no inquiry at all.
You admitted the charges?
No, my lord. There was no charge sheet at all. No inquiry. They keep me under suspension under Annexure D, page 87, where they say that inquiry will be held. Kindly see for a minute to page 87. This is the resolution keeping me under suspension. Kindly page 88. From the bottom about 5 lines. So and 88. So and so Shashikala, that is me. Clerk cum data entry operator and Mohan B. and more Gram Panchayat are to be suspended from today till further orders pending departmental inquiry as per provision of section 62D of the Karnataka Gram Swaraj Act. No inquiry was held. Straight away order for dismissal at page 134. Madam. And this honorable court in several of the judgments of the similar nature of a data entry operator who had terminated, I held that without a departmental inquiry, termination is bad. Page 134. I did not admit.
Let us see notice in
Please.
CA, notice written on 25th of April.
Obliged.
Delay.
Pro rata charges.
Notice
Yes.
after vacation. 10th of June.
Urgent, seal number 14. 50 issue.
Appellant, please. This Madam Lords, Lords may kindly turn to family tree at page number 186, because the property involved is found under the provisions of Karnataka Village Office Abolition Act. May- Page number 186 is the family tree. One Venkat Subbaya was the original proprietors and he was the holder of the office. And he died and his brother Venkateshaya was inherited. Thereafterwards, Venkapaya, then Venkateshaya too's name was incorporated in Barabaluti register. That is the wherein by showing that he was a officiator, Gumasta Shanbo. So this Venkataramanappa's family, that is Srinivasa, is the present appellant. And Lalitamma and then Narendra Prasad and Sridhara, they are the petitioners before the Honorable Learned Single Judgment. Now, page number 379 is the order passed by the Learned District Judge, that is Third Additional District Judge, 25/10/2014. It is a writ against the order of the civil court. Against the civil court writ petition, my lord. How can it, how will? No, that's what filed, my lord. That is, ordinarily they used to file CRP. Then the writ petition was also entertained by this honorable court. This writ petition was against which order? Where is that order? Which one? Writ petition was filed against which order? Writ petition is against at page number 379, annexure R15, please. It was under some special law? Yes, ma'am. Karnataka Village Office Abolition Act. But still, wherein Village Offices Abolition Act. Page 377? 379, please. 379 is the order dated 25/10/2014, wherein the matter has been remanded
to the special tahsildar, to the tahsildar to hold an inquiry. As against that, the writ petition.
Then the remedy other than appeal is not
My lords,
available.
this is the
So appeal
appeal
final.
provided under section 3(2), my lords.
Appeal
Page 380 may be looked into.
section mechanism.
Page 380. Appeal preferred under 3(2) of Karnataka Village Officers Abolition Act.
Correct. Against that, there is no remedy.
No remedy.
Against that, the contention of the appellant herein is CRP is to be preferred, but they have preferred the writ petition as such.
CRP means
Civil revision petition.
civil revision. Natural.
Section 3, subclause 2, I am permitted to read. Power of the deputy commissioner to decide certain questions, so on. So then, any person aggrieved by such decision may file an appeal to the district judge of the district within 90 days of such decision, and the decision of the district judge on such appeal shall be final.
While assailing the judgment and order of law on a single judge impugned in this appeal.
Is that page
Page
33,
33, my lords.
page 33.
Yes, what is that?
Page 33, may kindly listen.
Page?
33 of the learned single judge order.
Hmm.
The property involved is a service in arm land, and as per the annexure A at page number 60, may kindly be seen. Translated version is at page number 64. This Venkateshaya was
So
appointed as
civil
a
revision application is maintainable under which provision?
CRP.
This is, according to you, revision application is maintainable under which provision?
No, not revision.
Chandrasekhar.
2 is, that is the section 3, subclause 2, may kindly be seen. Karnataka Village Officers Abolition Act 1961. Power of the deputy commissioner to decide certain questions and appeals if any question arises. Now, then next is 3 subclause 2, may kindly be seen. Any person aggrieved by such decision may file an appeal to the district judge of the district within 90 days of such decision, and the decision of the district judge on such appeal shall be final.
So this was under 3(2).
3-2.
3(2) order got challenged before the writ petition court.
A
my lords.
3-2 order was challenged before this honorable court, before learned single judge, by the respondents, contesting respondents. That was allowed, and as against that, I filed this writ appeal.
Tamanna will also apply. Tamanna said.
We'll
will
examine
accept
it
this
next week,
in
my
such-
lordships.
In this circumstance.
But the maintainability issue was not raised before the learned single judgment.
But I have taken a contention in the statement of
Lord
objection.
learned advocate Mr. So-and-so for the appellant and learned additional government advocate. Chandrasekhar, who appeared upon service of copy of the petition in advance. The challenge in this appeal is directed against judgment and order dated 24th July 2024, passed by law on a single judge, whereby law on a single judge upset and set aside the order of judgment and order dated 25th October 2014, passed by learned third additional session judge Tumkur in miscellaneous in MA into VOA number 25 of 2008, which was an appeal under section 3 into bracket 2 of the Karnataka Village Officers Abolition Act 1961. Full stop. Thereby, the said court remanded the case back to the competent authority for reconsideration. It was seriously contended that it was not permissible to invoke the writ jurisdiction against the order which was set aside by learned single judge, and that the petition itself was therefore not maintained. Full stop. Prima facie, there is substance in the content. The appeal is admitted. Shall we say that remand proceeding may go on, but final decision shall not be taken?
Pardon?
Remand proceedings may go on, but final decision may not be taken.
Remand?
It is remanded.
Not remanded, my lord.
Yes, yes. Yes.
Remand order was set aside. Remand order was set aside by the learned single judge. The order dated 25/10/2014, remand order was set aside and grant was granted in favor of the contesting respondents.
Even then, same order. Remand proceedings may go on.
No, now what now?
By way of paid interim leave, it is directed that no final order shall be passed in the remand process.
I have not filed any application for interim relief. Interim relief, I have not filed any application, my lord.
Not paid.
Not filed. Only notice delay is there. That notice has to go.
It is delay.
Yes.
Then we, then notice only. Keep this order typed and keep.
I'm sorry, sir.
Only notice returnable on 11th June. It is not, there is no delay, Mr. It is
Sorry.
14, so this order will remain. There is no delay.
Yes.
So you have not filed stay application.
Stay application I have not filed.
Appeal is admitted. Yes, next. 15.
A date may be given, my lord. A date, short date may be given, my lord. Senior is now.
But you have got the remedy under section 17 of the. You go there, rightly disposed.
Senior is out of station. She's not well.
You are aware about the controversy or not?
Huh?
You know about the subject matter or not? Don't know. 17th April. As requested by learned advocate on the ground that the senior counsel who is to conduct the appeal is not available today for personal reasons. Next. But we can, all right. Here also 26 days delay.
Please.
Notice
There is
written.
one more connected matter, my lords, wherein my lords have already issued notice on the delay, 1866 of 2024.
25/4. 25/4.
That is ordered to be listed on 29/4. Connected matter is, my lords, writ appeal number,
29/4. 29.
connected appeal number, my lords, 1826 of 2024.
To be listed with appeal number 1826 of 24.
In order to be listed on 29th of this month. In the meantime, my lords, government advocate may be directed to take notice in my lords, sir. Respondent number 1 to 8, my lords.
Learned additional government advocate, the Harish accepts notice for number 1 to 8. Respond number 1. Yes,
9
please.
is on KV. Great.
For 17.
Lord, state appeal 812 days delay, madam. State appeal 812 days delay.
Pardon. File.
812 days delay, state appeal.
That is there. Notice. Very low, very long delay. Anyway, 18th of June.
No. Appellant is the Urban Development Authority, madam. A public action was called for disposal of the commercial site, madam. The respondent number 1 is the highest bidder, and he has paid 25% of the amount. Remaining amount, my lord, he has to pay within 45 days, madam. He has not paid so. So a notice was issued to cancel. Agreed by that, he has challenged before the learned single judge. Learned single judge, my lord, without considering Rule 6(3) CD, my lord, have allowed the respondent number 1 to pay the remaining amount and directed to execute the sale deed. And the case is posted after disposal, it is posted tomorrow for compliance. Rule mandates, my lord, that within 45 days, if they won't pay the amount, my lord,
So who is, you are the successful bidder?
no, man, I am the authority, my lord.
You are the original?
But
Who are you?
my lord, I am the Ramnagar Urban Development Authority. I have actioned the settlement. My lord, Rule 6, my lord, stipulates that within 45 days, they have to pay. There is no provision to relax the time limit.
Rule 6.
Even the terms and conditions stipulated in the public action and also confirmation letter, my lord, there is a clear, my lord, within 45 days, they have to pay the minimum balance amount, my lord. Rule 6, annexure H and J have been challenged.
Where is this order? 29th of
29th, my lord. It is annexure,
September. Where is that order?
it is annexure. Annexure H, my lord.
Right.
Annexure H, ink page number 55, translate copy 56, my lord, lost 57, my lord. As per the above rules, who do not pay the amount within this prescribed period as referred to by the
No, 29/9/12, which is
29. That's the public action, my lord.
no, which is what is under challenge in the
My
petition?
lord, annexure H and K, my lord,
H and K.
please. My lord. Annexure H is the cancellation letter, my lord. Ink page 57, last param.
The amount you accepted. I know. No,
My lord, the thing is, my lord, rule 6, my lord, it is very
Not
clear.
not only you accepted the amount, entire amount, but you waited for 6 years.
That's true, my lord, without our this thing, my lord, unless and until there is a relaxation to that this thing, my lord. If they pay, my lord, it cannot be accepted, my lord. Rules doesn't permit. May I read the rules, please?
The court will not permit you to take benefit of your own
My lord,
conduct.
for that, we will pay the interest whatever has been given, my lord. Because, my lord,
You want to cancel the auction in the favor of the respondent?
pardon, sorry,
You want to cancel the auction in favor?
we have already cancelled, my lord. And ask them to take back the amount.
Sorry.
Lord, the honorable affects court, my lord, in similar situation. Please, my lord. It's mandate, my lord, that rules cannot be. Para 3, my lord. The argument with regard to the above relief declaration, if we go order of the learned single judge does not seem to have been advanced before the learned single judge for consideration, be that as it may, we are considered opinion that as per rule 6, rule is mandatory in nature and no discretion is vested with the Bangalore Development Authority either to forfeit or grant exemption. And in another case, my lord, similarly. Para 6, my lord. Para 6, I under italics, my lord. Condition of allotment of sale site. Allotment of site under these shall be subject to following. The allottee shall within a period of 60 days from the date of receipt of notice, allotment of
You
authority.
accept the amount.
Why not?
Why did you accept the amount? Charge
Lord,
interest of 20.
What happens, my lord, without this thing, my lord, our knowledge or like that, my lord, it will be deposited in the
Not acceptable, nor believable. You whiled away 6 years. Accepted the entire.
No, my lord, before.
Not fully well.
No, it came to our knowledge only when he gave a representation to the execute the sale deed, my lord.
Complete ignorance.
My lord, rule 6, my lord. If that they doesn't pay the amount, my lord,
This is auction of what, property, some
please,
property.
please, reaction, my lord. Because my lord, it,
So what is the auction amount?
pardon,
What is the auction amount?
26 lakhs, my lord.
So you deposit 55 lakhs and we'll issue notice.
55.
Nice, well.
It's too, it's an authority, my lord. It's under huge loss. Only by developing the,
Not possible, Mr. Yom, because your own conduct, you have defeated yourself, dismissed.
much.
Number 19, to V. Siddaramaya.
Page number 29, annexure D, my. Page number 29, my lords, annexure D.
Page number
29, my lord, 29. My lord,
23.
29, my lord, 29, annexure D.
What is it?
Says, state, my lord, at place. My lord, appellant is Nasrullah Sharif, and right hand side is owner of this property. Right hand side, house of Nasrullah Sharif. My lord, and left hand side, house of Jakir is the third respondent. My lord, in the top, my lord, there is a, earlier there was a conservancy. It runs nearly about 1 kilometer. This conservancy used for drainage purpose earlier. Thereafter, my lord, there is a KB compound wall and KB office is situated. My lord, this after introduction of master plan, my lord, this conservancy, the underground drainage system was introduced in Tumpur, and this conservancy has not become useful for the public purposes. So entire conservancy has been blocked by the several landowners. This appellant being a senior citizen, my lord, he himself and his wife, aged 77 years, and dad were residing in the house. For the security purpose, my lord, this they have installed the grill to the conservancy. So not only this appellant, my lord, the entire conservancy, nearly about 1 kilometer, has been utilized by all the adjacent landowners, as it is not needed for the corporations at this moment. In view of the introduction of underground drainage system, UGD system.
Sorry, there is nothing before learn a single judge. Before learn a single judge, the appellant as petitioner had called in question the intimation letter dated 30th 11/24, wherein it was stated to the petitioner that he had encroached upon the conservancy and the road, and that he was required to remove the encroachment. Full stop. Learn a single judge allowed the petition directing the Dispatch number 1, Tumkur, Mahanagarpalika to remove the encroachment within 2 months. Paragraph. It is against the aforesaid order that the present writ appeal is filed. Full stop. While directing the Tumkur Mahanagarpalika to remove the encroachment from a learned single judge in terms recorded a finding that there is an encroachment. Full stop. This finding was based after the status report was obtained by Tumkur Mahanagarpalika, which was directed to instruct the engineers to conduct an inspection and file a report to the court. Full stop. The report was filed and the encroachment was indicated. The photographs are also produced, which were appreciated by learned single judge. Paragraph. It is recorded by learned single judge that pursuant to the order passed by the court, the assistant executive engineer had visited the spot and conducted the court inspection. It was stated that the assistant executive engineer was present before the court who produced the sketch prepared relating to the site in which the portions of encroachment by the petitioner as well as response 3 were clearly indicated. Thus paragraph, the encroachment is a matter of fact, full stop. A finding of fact has been recorded by learned single judge that there was an encroachment done by the petitioner for the conservancy and the road, which was based on the report of the assistant executive engineer who had inspected the spot and also produced the photograph along with the sketch. The encroachment was established in that full stop. In that view, the direction was issued to the Tumkur Mahanagar Palika to remove the same full stop. No error could be booked in the order of learned single judge. In the facts and circumstances case, the appeal is meritless, it is dismissed.
Serial numbers 21 and 24 are identical, my lords. Similar circumstances on 20th of March, we're pleased to issue notice in writ appeal number 338 of 2025. And in order to balance the equities, your lordship said permitted the state to come out with the final select list as directed by the learned single judge, but not to displace the appellants therein.
But here there is a delay of 14
Yes,
days.
but there is a delay. That matter is posted on 3rd of April, madam. That is day after tomorrow. In the meantime, if the delay could be.
Your appeal?
Madam.
Pay for R3, my lords. Just one submission. My lords, this is a case of clear illegal appointment, my lords.
But today we condone the delay.
It's there for 3rd of April, my lord.
3rd of April.
Connected matter.
Delay can be condoned today.
My lords may have it on that date.
Delay can be. Appeal will be kept. Having heard learned counsel for the respective parties, the case is made out and sufficient cause is shown to condone the delay of 14 days.
There's also an IA for permission to file.
He is for private respondent.
He's for the private.
I'm for R.
There are two IAs. One is for permission to even file the appeal because I was not arrayed as a party before the
No.
single judge.
Is there any private respondent?
Yes, there are
I'm
private
private
respondents. He's
respondent,
for the
ma'am.
private respondent.
Sufficient cause made out from the evidence in the accompanying affidavits.
Give
In
it.
that view, the
Give it. Give it.
interim implication is allowed and by condoning delay. So this is order in IA number 25 of 1 of 25. What about the other? The appeal shall be listed on 3rd April
3rd April.
as the cognate appeal is slated to be listed on that.
My lords, but to see that interim order, in order to balance the equity so that the private respondents also are not affected.
You appear for all the respondents,
No, my lords, I only appear for the petitioner.
notice written on 3rd April.
3rd April.
This by and summons is permitted.
Let the state not terminate my employment. I'm sure they want in 2 days, but.
My lordships may say the same order as such, my lords. We won't disturb anyone. We'll be at liberty to publish the list,
Yes,
but
my
we'll
lords.
be not.
In
not
fact,
being,
which is why my lords passed that order. So the private response also are not
That
affected.
appeal it is passed.
Yes, my lords, in that appeal. I just passed on the order. my lord.
connected appeal, there's an interim order.
That doesn't affect the private respondent at all.
So this will apply.
Yes.
His submission, my lords, is that they may be directed, because already 2 months was given for compliance, my lords. They may be directed to publish the list as soon as.
On that.
Because it's been 2.5 years, my lord, since I have not received any appointment. at
3rd April is day after 2.
Yes,
my
my
lord,
lord.
yes.
So we'll see
The
on
same order is being passed, my lords, in that. The same order is in that. It won't apply because it's qua that appellant. I'm just a little concerned that.
Since the appeal is cognate, since this appeal is cognate to writ appeal number 338 of 25, the interim order passed in therein shall govern the present parties also.
Grateful, my lords. Serial numbers 21 and 24 are identical.
81 and 84 also go.
21 and 24.
21 and
24 also.
24 will go to 3rd April.
Grateful.
Office objection will remove whatever.
Only in respect to annexure C, my
Office
lord,
objection shall be removed before the next date.
please, my lord. May make a submission, my lord. Annexure C, we have filed the translated version, my lord. the office wants to meet to file a type copy, my lord. In fact, the translation versions are before your lordships. My lord. Please.
Number 22. Mr. Nandit Patil.
Appellant's counsel. But the notice is deferred on me by the learned single judge. Though I am a party in the writ petition. Your lordship may kindly come to the order, the cost at page 15 is the learned single judge's order. I am the fifth respondent therein at page 16, if your lordship sees. Notice is deferred to me. That's the chief engineer of Bagalkot Town Development Authority. The petition had been filed by an MLC seeking, my lords, that he should also be allowed to participate in the activities of Bagalkot Town Development Authority. The chief engineer had recommended, my lords, only recommended that any action as per the state government's directive will permit him because he is an MLC. The act permits only MLAs, but if the government says, we will do it.
What is the controversy?
Controversy was the petition was filed by the petitioner, my lord, seeking that he should be allowed to function as a member and participate in the meetings of this Bagalkot Town Development Authority, which was, my lord, the fifth respondent. That was essentially the government had said, no, there is no permission for that. Only MLS can be permitted. The writ, my lord's notice is deferred. Notice is not even issued to me. It is deferred. But then instead of going into the merits, the prayer in the writ petition was only that. Now the learned single judge holds Bagalkot Town Development Authority is only a paper entity. It has no funds. It has nothing. Now that affects my functioning itself. That was not even the prayer in the writ petition. If your lordship sees the findings, my lords.
May
Now, my lords, I am.
Let us see the prayer in the petition.
Prayer in the writ, your lordship should get, my lords, at page 74, running page 74. One was quashing of order at Annexure G, which is at page 177, the translated version, my lords, from the government. The other was a mandamus to enforce our letter and the other letter, recommendation letter.
So as a member of legislative assembly or
Council. As a council,
the petitioner and authority was entitled to participate in the.
Whether he was entitled, the government initially said he is entitled to.
As per this 177.
Yes, my lords. Now, then they said he is not entitled to. That was challenged.
Then who challenged it?
The petition, the fifth respondent in the writ, that's the MLC, a member of Legislative Council, because it was given that only member of Legislative Assembly are permitted, not legislative.
One second. The communication dated 10th of September is page 177.
Yes, my lord, 10th of September.
So that was challenged by whom?
By the petitioner, that is Pujar, who is the member of Legislative Council.
Okay.
Because he was not permitted. His prayer was, permit me to attend the meetings.
Permit her to attend.
Now, my lords, the court goes into some other issue without even issuing notice to me.
One second. I am not clear.
Yes, my lords.
What was permitted by page 177?
177, he did not permit. His request to participate in the meetings in the petitioner, that is the member of Legislative Council.
The earlier order of permission.
1 second. Name.
Lords, what happens is Mr. Pujar, who was a member of Legislative Council, he wanted to participate in the meetings of Bagalkot Town Development Authority. On an earlier occasion, government said, yes, since MLAs are also allowed, even MLCs can. Then, my lords, the direction came to me as the chief engineer, you take action. We had written to the government saying, as per your directions, we'll take action. But, my lords, under 10/9/2024, communication at Annexure G at page 177, Government took a different stand saying that MLCs are not allowed to participate. That was what was challenged by the
Therefore, it was challenged.
challenged. Notice is deferred to me, that is the Bagalkot Town Development Authority. But the government, the state, the learned single judge has now held, you're only, the Bagalkot Town Development Authority is only a paper entity, it has no functioning, nothing. We have about 280 engineers working under me. This is only for the purpose of rehabilitation of persons, my lords, whose houses were submerged in the Almaty Dam. At least I should have been heard in the matter. It's a serious matter where findings are given. I am only a paper entity. I'm not even, that is not even the prayer of the petitioner. At para 62 again, my lords. And this authority was formed only because there was submersion. Only for the purpose of rehabilitation of the town residents.
This Bagalkot is merged with the.
My lords, it was merged. The entire town got merged when Almaty Dam was being constructed. So a special authority came into existence known as the Bagalkot Town. There's a new town.
So today it exists.
It exists. And I am also in existence. I've said in my writ appeal, there are about 280 engineers who are working there. We are only looking after the rehabilitation, nothing else, my lords. And today to say that I am only a non-existent entity, a paper entity, without even hearing me, 281 sanctioned posts are there. At page 11, I have stated so in my writ appeal.
May I submit your lordship?
You are for original petition.
Original petition.
I am the petitioner. The earlier order, my lord, on 16/8/2024. I submit your lordship.
The original petitioner
My lord, may I submit your?
happened to be member of Legislative Council. Yes.
My lord, on the earlier order, my lord, the state has permitted him to participate in the, my lord, Bagalkot Town Development Authority. That was subsequently, my lord, without notice, without hearing the, my lord, the petitioner, that was withdrawn. That was called in question by me. My lord, the appellant says that we have not been heard. The statement of objection filed by the appellant, your lordship, I kindly go to, my lord, my statement of objection. All along, my lord, assisting the, my lord, the government by the, my lord, the chief engineer. The statement of objections, my lord, my lord, in the event, if they are affected, the state is the party to file an appeal. They are part and parcel of the state. The state has defended their action and filed their statement of objection. And my lord, the appellant has sworn to an affidavit. They have no lower standing, my lord, to file an appeal independently, without, my lord, from this side. If they have been heard, statement of objection, lordship, may kindly, my lord, go to page.
180.
The statement
180
is totally wrong, page 184. The affidavit was sworn by the, my lord, the appellant. How can say them they have not been heard? They have filed a detailed statement of objection. The state has, my lord, taken responsibility on their shoulder to defend the action of the appellant. They cannot, for they have no, my lord, the independent legs to stand.
Lords, statement of objections is filed by the state. Assistant engineer has sworn to on behalf
My
of the
lord, for
state.
all the respondents, state has
I don't
defended.
know how my learned friend is affected by saying BTDA is a paper entity.
Totally, my lord, the statement is totally incorrect. My lord, the affidavit, your lordship is before your lordship is page 184. The assistant engineer of the, my lord, the appellant has filed a statement of objection. He was assisting the government. At the best, my lord, the aggrieved party is the state.
Lord, it can be nobody's case that BTTDA is a paper entity.
And
because
my
they
lord,
want participation in the BTTDA. My lords.
He wants to participate in me and today he says it's a paper entity.
It is not even the original petitioner's case that it's a paper entity.
and that is our statement. You
And
have
my
not read the
instructions
paper.
are even government is filing an appeal in this.
Government has given my instructions, my lord. Government has given an opinion that's not a fit case. How can they file an independent party? Government has given my instructions, my lord. The government has, my lord, given an opinion that is not a fit case. And they are all along, my lord, sailing with the state. If they are aggrieved, state has to file. And the statement of objection filed by them only in the writ petition.
By me.
Are sworn to an affidavit. Now they are coming up, my lord, we have not been heard. This has, my lord, in detail, my lord, the learned single judge with great respect has taken pain, my lord, in respect of all the statutes and referred, my lord, in length, my lord, and they come to a conclusion in view of, my lord, the Karnataka Urban Development Authority Act, my lord, that is section, my lord, section 78, my lord, it has been enacted in the year 1987. In view of enactment of 1987 Act, my lord, the authority, that's the Improvement Board Authority, is not in existence. And my lord, the learned single judge directed that, my lord, the authority only is existence is the KUDA, Karnataka Bagalkot Urban Development Authority. The only ground urged by my learned friend, my senior counsel, my lord, that we have not been heard, the total incorrect. They have filed the statement of objection before learned single judge and assisting the, my lord, the government. The government has not come forward. A body, my lord, which is not in existence from 1987 onwards. And my lord, they have brought an amendment to the, my lord, the Irrigation Act. Just to cover up their latches, my lord, to Irrigation Act, which is nothing to do that.
That's all. Yeah, like, what did you read? He filed a writ petition seeking to challenge the communication dated 10/9/24 issued by the under competent authority, the irrigation department, whereby she was not allowed to participate in the meetings and proceedings of the Bagalkot Town Development Authority, BTDA. Full stop. Prayer was made to direct response 3 and 4 to implement and enforce the earlier communication whereby such participation was allowed. Full stop. While disposing of the writ petition, so what is the relief granted to him or not?
No, he also has not been given any relief. He came to the court to participate. Today, my
Writ
lord,
petition came to be allowed. The writ petition came to be disposed of. Although without granting any relief to petitioner, but in the process of disposal of the petition, learned single judge made some observations regarding the status of the BTDA and its existence. Full stop. It was recorded by learned single judge in paragraph 67 of the order that only Bangalore Urban Development Authority, only the Bagalkot Urban Development Authority would be the proper authority to administer the planning and development work. Full stop. In paragraph 16, subsequently, it was observed by learned single judge that the existence of the BTDA was meaningless. Paragraph. Thereafter, following observations were made regarding the continuation existence of the BTDA extracted from paragraph 69 and 70. Extracted from 69, the court, unless they look at KUD Act. It was directed that the BTDA cannot exercise or discharge any of the functions after quoting. Functions since the provisions under which it was constituted are inapplicable. Full stop. It was then observed that the petitioner, it was then observed that by virtue of the legal position, the petitioner would be treated to be the member of Bagalkot Urban Development Authority. And that the Bagalkot Urban Development Authority alone will govern the development of the urban area. Full stop. It is the aforesaid observations contained in the order, which are with the appellant BTDA is aggrieved by. Full stop. It is evident that learned single judge has manifestly exceeded the four corners of the challenge and the controversy in the original petition. Full stop. The observations made by him regarding the existence, functionality, and efficacy of BDTA are in excess of the jurisdiction which learned judge could have been exercised, having regard to the compass of the controversy in the writ petition. Full stop. A strong prima facie case is made out. Full stop. The order and the observation of learned single judge shall remain stayed and shall have no operation, please. Appeal is admitted, then the
Respondents 1 to 4, my learned friend, government advocate could take.
learned additional government advocate.
Respondents 1 to
Who
4.
heard learned senior Phanindra and learned also for number 1 original petition. Learned additional Mr. Chandrasekhar accepts notice on behalf of number 1 to
Respondent.
accepts the notice of admission of the appeal on behalf of
1 to 4.
1 to 4, whereas learned advocate for original petitioner accepts notice on behalf of the original. This one number 1, please.
Number 23. There is a delay of 208 days, my lord, in filing the appeal. Matter, my lord, is writ petitioner sought regularization. They are called monsoon gangman, my lord. It's a temporary post. During only monsoon, my lord, I have to engage transmission utility, my lord, and distributors, my lord. They have to engage services of gangman to prune, my lord, tree trunks. My lord, these petitioners, my lord, had worked for 2 years. 96 and 97, my lord, 40 days and 50 days, my lord, respectively in those.
Delay of 208 days.
Yes.
Notice returnable also. Notice returnable on. Notice returnable on. Delay.
In addition, my lord, I'll also serve the counsel, my lord, who had appeared for the writ petition.
24th of April. Notice shall be served in addition to the normal mode, to the counsel appearing for the respondent as well.
Right.
Notice both in appeal and. Somebody wanted time.
24 is urgent. Still number 25.
My lords,
PMPA.
I appeal for the petitioner, my lords. In this case, objections copies have been received. I will file my rejoinder, my lords, to this.
This. That
By Bane lands, Sago lands, Bane lands case, my lords.
Conversion of plantation lands in Coorg are concerned. I have filed my statement of objections, bro. They want to file any rejoinder.
Rejoinder, I will file it.
you want
Next
time,
date. Yes, my lords. Any date may be kindly be fixed. My lords.
21st of April.
Much obliged. My lords. Interim order may kindly be extended.
Interim order shall stand extant.
Number 26. Mr. Ramesh Naik L, 14%.
I am the petitioner, my lords. My lords, the matter is about street dog issue. Street dog matter. On the last occasion, state has made a submission that they would file an additional report.
You file additional. Learned additional government wants to file additional pleading, stand over to 24th of June.
Like,
Great.
Number 27. The case Naresh Santosh.
For point number 6 and 8, my lord. Point number 7. Pay for some time to file an objection. Now filing my objection.
Don't file objects.
Now this
What is it?
petition has become infractious, my lord. Because
my lord, pollution caused due to the functioning of a hot mix plant, my lord.
this petition has become infractious, my lord, because the prior is to direct the fourth respondent to direct sixth respondent to close down the hot mix plant. The already direction has been issued by the fourth respondent. And we have also responded to that. That is respondent number 6, that we have surrendered the CFO. That is the only prior, my lord. So therefore, the petition itself has become infractious.
Where is that direction by Pollution Control Board?
Filing the objections.
My lord, now it is the respondent number 8 who's running the hot mix cement plant, my lord.
Annexure A, my lord. This is at page 11.
Page?
Page 11. Annexure A.
Yeah. Where's Manish? Where is the Manish?
Who is number 8?
My lord, 8 is the present, my lord, a hot mix plant which is running, my lord, because of which, my lord, there is dust pollution affecting the lives of the villagers.
Nothing survives, Mr. Who appeared?
They have
Sir.
sought for some time. He appears for respondent.
No, nothing survives. Learned advocate, Mr. So-and-so, so-and-so. You're for Pollution Control Board?
Now, I'm appearing for respondent number 6, Lanco. I'm the one who is operating the hot mix.
For 6 produces on record along with the affidavit order dated 8th August 24 of the Karnataka State Pollution Control Board, whereby respondent 6 is directed to
Annexure A and Annexure B, my lord. 2 orders has been passed under Air Pollution Act and Water Pollution Act.
close down the operations of the unit. The orders are passed in this regard under section 331 into bracket capital A of the air into bracket prevention and control of the pollution bracket over Act 1981, as well as similar order which is passed on 24th February 25 under the provisions of the 33 section 33 of the Water Prevention and Control of Pollution, Act 1974. In that view, the present.
My lord, may I persuade my lord to please see paragraph 10 of the writ petition. My lord, initially it was given to them, but now it is given to respondent number 8. My lord, paragraph 10. Gaurama had leased it out earlier to Sri Venkateshwara Industries. My lord, thereafter, my lord, paragraph 10.
So it will survive.
It'll, my lord, Mahesh Chowdhury is not there. He will be able to
So
tell. us.
both the number 6 and number 8 are joined.
My lord, I wouldn't know
No,
that.
let it. We'll simply say the learned.
I'm appearing for both, my lord, respondent number 6 and 8.
Files affidavit, along with which he produced copy of the orders of the passed by the Karnataka State Pollution Control Board dated 24 February 25 under the Water Act, under the Air Act and Water Act, closing down the respondent 6 unit. Full stop. Learned petitioner is not present. In that view, to be listed on 7th at 2:30.
Obliged.
You not file this on affidavit. You not supported this on affidavit.
No objection, my lord.
Oh.
I will file.
In the meantime, the present objections which are filed shall be filed on affidavit and shall be produced on record before the next day. Just simply affidavit.
Achha.
28 is urgent. Number 29, Mr. Rajendra S.
Petitions counsel by me in this matter. What's two grievances.
We'll ask them to file reply or it is filed.
What's reply is filed, my lords, by the private respondent,
Right.
but yes, the
Respondent
state,
number 7,
the
I
state-
appear.
State will have
the
all.
state also has to file its reply, my lords. There is a
Well,
fact-
I'll file, my lord, because it's for encroachment. My lord may
Right
grant me 2
respondents have
weeks.
filed their reply.
My lord, may I make a submission appearing for respondent number 7, educational institution. My lord, there is a suppression of fact. This particular petitioner has filed so far 7 writ petitions. And the details are given in the paragraph 7. Paragraph 21 at page 8, without disclosing the filing of the earlier writ petitions. This petition is filed and he says that there is encroachment. He is not a public interest, a person with vested interest is filing this petition, and educational institution is at it is suffering because construction is after obtaining the permission, construction of the building. All that I have placed on record. Now after the
Any-
month of
any-
May,
Any interim order is operated.
there is no interim
No,
order
my lords.
because of this, my lord. Panchayat is not issuing the door number. The construction is complete. Construction is in accordance with the sanction plan and the license.
my lords, there
And
are,
door numbers are not issued.
my lords, there are 2 constructions which is put up by the college. One is by violating the Lake Act, which requires 30 meters setback is to be left. I produced the photographs to indicate that even by encroaching into the lake area, they have put up the construction.
We'll
That's a
keep it on
statement. Yes, that's a statement
that-
which has to be ascertained and the state government will have to make a response to that.
Pardon me, my lord.
22nd will file.
Lordships.
Reply by the state, while the other respondents have filed the reply. The state's reply is awaited. The same shall be filed as stated by an additional government advocate from Sri Nigro on or before 22nd April. Stand over to 24th April.
24th, I am not available. Can it be on 22nd itself? my lords?
22nd.
Very well.
You don't make a mention there. Yeah.
This is number 30. So Shashwat Ms. Prakash.
My lords, may I seek a short accommodation, my lords? The senior is unwell, my lords.
Microchips.
It has become infructuous, my lords. What he has challenged in the writ petition is Annexure C, request for proposal issued by us in the year 2024. It is a short-term tender which we have not acted upon. Therefore, my lords, nothing survives in the writ petition. Page 82 is the short-term tender that we have issued, which he has questioned.
So there is no further action on your.
No further action is taken pursuant to the impugned tender.
I will verify, my lords. Kindly have it on 15th. I'll verify and I'll.
We will forget.
After vacation.
And in the meantime, they might issue press. 7th.
Please, my lords.
7th at
2:30, my lords.
Learned advocate, Mr. Swans. You're for?
I am for BBMP, my lords. Second respondent.
Stated that the present petition, the prayers made therein have become infectious in as much as the RFP dated 29/2/24 has never been,
It has not been acted upon.
acted upon, full stop. In this regard, learned advocate Swans petition shall take a stand on that.
I'll verify, my lords.
Verify. We'll verify whether the standard is acted upon or not. Sure, we will start.
Number 31.
I appear for the appellant, my lord. My
I'm
lord,
appealing
may
for
I
the
seek a
case.
short accommodation since my.
Second respondent.
31 is also PIL, appeal,
My lord,
delay of 7 days.
lord, the appellant,
Delay is gone down?
not delay. She has undertaken to pay the amount by 3 installments, and it has not taken so far. I have filed my memo. ಕೊಡಿ.
ಇದನ್ನ ಹೇಳಿ.
So what is wrong in this now?
My lords, in the order passed by the learned single judge, the affidavit which the appellant had submitted before the learned single judge said clearly stated that the appellant is ready to clear the loan. However, after clearing such a loan, the discharge certificate along with the original documents may be handed over in her favor. With respect to the scheduled premises, my lord, she is the 50% owner and the first respondent had mortgaged the said property to the second respondent without my signature on it, even though I hold 50% of the said property. In spite of which I was ready to clear the first respondent's loan. However, my only condition was the original documents may be handed over to me, including the discharge certificate, which has not been culminated down in this order, my lords. Due to which, in this order is, since that has not been stated well, and it all in paragraph 4, it only states that may be disposed in terms of the undertaking taken by the petitioner.
till this day, she has to pay 37,63,000.
You are for first
I
one.
am for the second response.
First one.
Responding to bank.
Bank, Bajaj
Bank.
Finance. Bajaj Finance.
So the amount is
So
paid.
they have not paid the entire amount. Still, he has to pay 37,63,000.
Who has to pay?
The
Under-
appellant.
Under settlement.
She has undertaken that she will clear the loan amount and thereafter she is entitled to get back all the papers.
My lords, when the appellant had approached the bank had clearly specified that she is not entitled to the original documents. She was she was ready to clear the entire loan, but the bank had informed her that she cannot be entitled to the discharge certificate, neither the original documents, which she had intended to take after clearing the loan.
And moreover, Annexure H, my lord, she also filed a suit for partition. It is Annexure H, 106 page number. She has filed a suit against her husband that she is entitled for her share. Suit is pending. Till November, she has not paid any amount. Reinstallment is over. Because husband and wife are the joint owners. Till she clears the entire amount, then the bank will return the documents.
If the bank is ready to return the documents, the same may be taken on record, my lords.
Yes, sir.
Why should we interfere in this? Anything?
My lords, in paragraph 4 of the order, specifically it just mentions that as per the terms of the undertaking. However, the terms were not culminated down, due to which when I approached the bank to pay the loan, the bank responded saying that I'm not entitled, my lords.
Appellant is the petitioner in the.
So this undertaking is filed by you?
By the appellant, my lords.
Where is that undertaking?
It's in the way of affidavit at
It is on affidavit?
if it is an affidavit filed before the learned
Where is-
single
where
judge.
is-
It was separately given. In a memo, it was separately given, my lords. In the affidavit, it had mentioned that
Where is, copy is there?
a copy had been served separately by way of memo to the court, my lords.
Memo.
We had served it to the- I'll serve a fresh.
ಹೇಳಿದ್ರ ಅಂತ.
He says the banks, the finance company says that 17 lakhs are to be due.
I'm willing to deposit, my lord, as long as the
Let her deposit, my lord, because she is entitled for half share. The remaining half share belongs to the husband. Since there are some differences.
Who is for number one?
the husband, my lord, the husband of the appellant, who has come on record, but he hasn't made any objections or any
Not appearing.
Hmm?
Number one is not appearing in this court.
not appearing, my lords.
And then what is to be, if you are ready to pay 17 lakhs, then you will get the documents, that's it.
No.
both of them, both of the,
If the wife pays the remaining balance,
let her pay, my lord.
then what will do?
Now, it is pledged by her husband. Her husband has got half share in the property in question. Both of them has to come and give a statement before
The settlement between the.
settlement is
I
there, my
was
lord.
worrying.
But again, he will not come and say that my papers are pledged.
Besides, my lord, I haven't taken any loan. I'm not on the mortgage. I haven't signed the loan pay documents.
Number one has not questioned the action of number two bank. It is
Certainly.
in light of the amicable settlement between the petitioner and number two, that is husband wife, and having regard to the fact that number one has not questioned the action of the bank, petitions can disposed of in terms of the undertaking given by the petitioner.
Yes. In that case also, husband is necessary party to come and say.
He is there but not appearing. What we can do?
Then he may go for another litigation against the bank without my consent or
Put on
my
affidavit.
knowledge.
You put on affidavit 17 lakhs are due.
Yes,
File affidavit that effect.
yes, I will file.
Then you pay it.
2 weeks,
Close.
2 weeks time may be granted.
Certainly, my lord. But
I will file affidavit.
Whatever future dispute occurs, you handle it in accordance with it. You are bound to abide by the
Yes.
undertaking.
Certainly,
certainly, my lord.
Both of you rather.
yes, I will. 2 weeks time. ma'am.
No 2 weeks. On 15th, you do 15th.
15 for.
15. Loan and derivative transfer for the bank for the respondent number two. Bajaj Finance Limited owns time to file affidavit to substantiate his statement made today that rupees 17 lakhs is due to be paid by the petitioner. Pursuant to which, according to him, the entire debt to the bank would stand discharged. Such affidavit may be filed on or next date, put up on 15th of
Much obliged.
15th, 21st.
21st.
And you, in the meantime, keep ready if you are willing to pay.
Certainly, my lords.
Thirty-two is urgent, seal number 33, to BB Patil.
33. Documents are ready. I couldn't file it, my lord. Section state.
Lords, on the
Objection
last date of
statements, I
hearing,
To file.
I'll file it in a day.
delay application objections, my lords, they've just served on us. They're seeking leave to file it in the registry.
When shall we give? After vacation
Day.
now?
After
19th
vacation,
of June, in order to enable learned educated respondent to file readings. Yes, next.
Date may be given, my lords.
Given,
Detail,
given.
please.
Date is
For
given.
the appellants in the 33.1, my lord.
Date is given.
My lord.
Date is given, shall be next.
Please, my lord.
19th of June, yes, 34.
Number 34. Sachin BS.
I have challenged the election by way of an election petition. I have challenged the election by way of an election petition before this court. During the pendency of the proceedings, I made an application for recounting. Recounting application was ordered and votes are being recounted. And after recounting, it was found that I have secured the highest vote and my opponent has secured lowest vote. Court holds that I should be a winning candidate in the election petition proceedings. Still, court refused to grant me a relief on the ground that as per Rule 71, I have not made an application before returning officer before declaration of result. That is only on the ground under which the relief before the election court has been denied. Challenging that order, my lords, I preferred a writ petition. Single judge confirms the order of the election court order. My lords, even single judge also quotes Rule 71. My lord, it is covered by the decision of the apex court. My lords, of course, that was the earlier view, which is of the apex court, that is uh, Rama Rati's case. That was earlier view, saying that unless you make an application before returning office for recounting, you cannot maintain a petition for, you cannot maintain election petition. That was the view of the apex court earlier. That view of the apex court has been overruled, and by the 3 judges bench of the apex court, which says that, just I'll pass on it, my lords. My lords, it is memo dated 25/7/2024, which is a part of record. What it says is that it is incorrect to hold that in an election petition, after the declaration of result, court or tribunal cannot direct recounting of votes unless the first party first applied in writing for recounting. There is no prohibition under the statute prohibiting the court to direct recounting of the votes. Party may not know that recounting is necessary till the result is declared. So therefore, my lords, the view which is taken by the court below is erroneous in the light of the apex court judgment, that is 3 judges bench judgment, which is very clear on the point that, my lords, recounting order which was not challenged during the pendency of the proceedings, which has attained finality. My lords, only on the ground, my lords, Rule 71, which I have not earlier applied before the returning officer for recounting, court has denied the relief. I draw my lord's attention to page number 22. My lords got it. Page 22, page 24, para 2. The part of record. Reason starts page 27, para 5 minutes.
Today you are enjoying some relief.
Please.
Some order is passed, interim order is passed.
No interim order is passed. My election petition is dismissed, which is confirmed by this court. Hence, I am in writ appeal. My lords, I have got 1 year period. In any event, if my lords interfere in the writ appeal, I'll get 1 year period. I can, if election is set aside, I'll get another 1 year period. That's all. My lords, if my lords, I placed a memo on record, the judgment decision of the apex court, that is Sohan Lal, 3 judges bench apex court.
So the election petition dismissed on the, upon counting of votes.
No, election petition was dismissed, my lords, during the pendency of the election petition. Recounting of votes was ordered, which has attained final, nobody has challenged it. After recounting, it was found that I have secured highest vote and my opponent secured lowest vote.
So why the election petition dismissed?
My lords, election petition was dismissed on the ground that,
Which judgment you have cited?
yes, sir. That is Sohan Lal's case. As I filed a memo. My lords got it, my lords? Page 2, my lords got it? Page 2. I draw my lord's attention to para number 9, page 4. It is similar to the Karnataka Panchayat Raj rules. Para number 9, page 4. My lords, again, there is a recounting of votes, rule 80, that is Madhya Pradesh Panchayat Raj rules. It is similar, my lords. Similar restriction also imposed in subclause 5. Kindly see rule 80 subclause 5. After the total number of votes polled in each candidate has.
Here recounting was ordered.
It is already ordered
Your instance,
at my instance.
and you succeeded.
I succeeded.
Then
Court also holds that I am entitled to be succeeded in the election. Election court rejects my election petition on the ground that I have not exhausted the remedy of Rule 71 of Panchayat Raj rules.
Is it 270?
71, my lords, kindly see, page 25. It is counted, it is quoted in the single judge order itself. Page 25. My lords got it?
Hmm.
71, recounting of votes.
Hmm.
After the completion of the counting, the returning officer shall record in the result sheet in the form number 31 the total number of votes polled by each candidate and announce the same. After such announcement has been made, a candidate made or in his absence, his
The
election agent, so and so,
returned candidate is party, Renuka. Is the returned candidate.
please.
Who appears?
My lord, respond number 3 and 4, my lord, they are on record, my lord. Council is on record. Respond number 3 and 4.
Who is for?
They have been served. my lord.
Who is the returned candidate? I mean, elected candidate.
My lords, returning candidate, my lords, elected candidate was represented before the single judge.
Who is the number 3 or 4?
My lords, that is respondent number 3, my lords, Renuka,
So who appears? Anybody appears?
They have been served, my lord, unrepresented.
served and unrepresented.
Not. None appears for this number 4. Number 3, who is a returned candidate. Full stop. This one 3 is to be adversely affected if the petitioner is to be allowed. Full stop. In that view, the court wants the stand of the respondent. In that view, comma, the court is not inclined to proceed on merits without the presence of this one 3 paragraph. The position on the board indicates that those out, none appears for number 3. Full stop. In order to give further opportunity, there will be press notice to this one 3, returnable on 29th of April. Full stop. Learned advocate for the appellant 6, permission to serve number 3 by hand delivery, which is permitted in addition to more normal mode of service. It is observed that if on the returnable date, respondent does not appear or does not cause his appearance, comma, in that eventuality, the court will proceed to consider the case on merits and pass approved orders in accordance.
Appear for the appellant. Original writ petitioner in the. for the single.
Delay of 40 days.
Notice has already gone, my lord. Notice is issued.
Awaited.
No, my lord. Respondent number 3, 1 and 2 is represented by the state. Respondent number 3 is served unrepresented.
COVID-19 is back.
No, my lord, I am suffering from a gum infection.
So we'll wait for the other side
Well,
to be listed on 9th of June. Yes,
Notice has been issued, my lord.
122 days delay. Delay is not gone down. How did you appeal for? Your state's appeal? No.
No, my. Delay is only 35 days.
Delay. Delay is gone down. The appeal may be listed on 17th April.
Number 37, state appeal.
Lord's delay of 82 days to be condoned, my lord, sir.
Found on. Appeal may be listed on after. Appeal may be listed on.
Well, can I request for notes anytime before vacation, because
Before
trees have been cut and auctioned by the forest department, but value is not.
vacation, then on 23rd April.
Please, very much.
Serial number 38, I seek a passo on my lord. Senior counsel is on his legs in another court.
Which one?
Serial number 38. I seek a passo.
Is on that writ appeal on an interim order where they had tried to seek stay of NCLT proceedings. The Naganand appears on the other side.
Yes. Seek a passo is
On that matter.
It's same matter.
Infectious.
my lord.
Last occasion, my
No,
lord had indicated that this should go. Mr. Naganand
Not
said that a
infectious,
settlement offer for settlement will be made. My instructions are that no offer has been received by us.
No, my lord, my instructions were that talks are going on for settlement. Your lordship
in-
had adjourned it on that ground. My lord, senior counsel is on his legs. Passover, my lord, will,
Talks are going on.
talks are going
My
on.
instructions.
How long it will go on?
Passover, my lord, will,
This is on an interim
senior
order.
counsel
If
will
they are-
appear.
they are
That's
sincere
my-
about settlement, it can get.
there's no
left.
interim order also in favor
It
of.
will happen to settlement talks if this petition is appeal is dismissed in the meantime.
That may be so, my lord.
So you take
After,
it.
your lordship may just have it in the afternoon, my lord, senior counsel will.
Today afternoon may not be possible. Day after tomorrow.
Much.
Finish this off like that.
We might not be sitting there.
Or second amendment.
There's some.
Lord, then may I request this indulgence on day after tomorrow, 2:30, we finish.
2/3, day after
Great.
tomorrow.
Great.
Much.
Number 39,
The appellant, my lord. Appeal in the section 37 of the Arbitration Act. Here it is a dispute arising out of between partners of an LLP, my lord. There is an arbitral award which I have suffered. And the court below has also upheld the award. That's why I'm before your lordship, my lord. Very interestingly, the award is all in favor of the respondent, who's the individual partner, and nothing against the LLP per se, my lord. If at all they suffered any loss, it should have been in favor of the LLP.
We'll hear on someday.
Yes.
The
Yes,
only
ma'am.
difficulty, my lord, they have already moved for execution. That matter is coming day after. 4th, it's posted, my lord, their execution.
We may.
Last
find-
time they said they will
we
not,
can-
but
Yeah, no, it was already filed.
Filed, yes, yes,
Execution
yes.
was already filed.
again,
That we will not take precipitative action.
very well.
In the interim, my lord, you had opined that we'll hear out the matter. If it may kindly be taken up to tomorrow or day after in the
Not
second.
tomorrow, day after, on 22nd, 23rd we'll.
Till then, even if notice goes, let them reply to the.
May let them not take precipitative action, my lord.
Yes.
Don't take any precipitation.
Yes,
Let it be.
my
I-
lord, my lord, let them give a reply till next date of hearing, because there is no
Let it not
tenable
go on
grounds.
before the
There
execution
is,
court.
my lord, just two submissions, my lord. There are absolutely no tenable grounds for this
That
section.
will consider.
But
37
that your
application.
lordship
It will
will consider.
Yes.
20 stand out to 23rd, since it was stated by learned advocate Mr. So-and-so for the appellant that the execution petition is filed. Full stop. Learned advocate Mr. So-and-so response states that however, no precipitative action will be taken in your dependency of the appellant.
Very well.
Till the next date of hearing. Till the next date of hearing.
Till the
That
next-
is 22nd.
Till the next,
22nd.
Yes,
23rd.
grateful.
Grateful.
number 40,
I am appearing for petition, my lord. Recall and condone the delay application to be filed, my lord. 565 days delay, my lord.
What is this? Yeah.
PL, man.
preserve the land situated at Attigere village. Why you want to preserve the land?
565 days, my lord, delay.
Grazing, formal land. They'll preserve it. One time. One time.
Recall and on the delay, my lord, 565 days. 14 to 23, my lord. Dismiss non-prosecution, my lord. Recall and on the delay application to be allowed, my lord.
There are 7 office objections.
Office observation, translation is delay, late, my lord. Translation copy is ready, my lord. And 1 week time, my lord, complies the office objection, my lord. My application is allowed.
One time.
My lord, the petition has
time.
been dismissed on
Time,
14.
my lord. Compliance office objection, 1 week time, my lord.
How much time you want to give to your council?
The matter is not reached, my lord. 14 to 23, my lord. 10 time and matter, my lord, not reached, my lord, matter.
No, learned government council wants time. So what time you will give to her?
The matter not reached, my lord.
Week, 2 week, 3 weeks.
2 weeks,
2 weeks.
compliance office objection.
Learned the additional government advocate 6 times. Full stop in response to the request. Learned advocate, Mr.
Petitioner, my lord.
What is your good?
Rangasomaya RL. Rangasomaya RL.
Rangasomaya says that he will give time.
2 weeks time, my lord.
He will give 2 weeks time.
Recall and condone the deal application allowed,
My
my
lord,
lord.
the petition is not on board as on date, my lord.
But he wants you to give, he wants 2 weeks time to be given to. Why don't you take it?
My lord, let the, my lord, petition is dismissed on 14.
Recall the and condone the delay application, my lord, allowed, my lord.
23. There's a delay of 565 days.
565 days delay, my lord.
Why should we condone it? 565.
My lord, I can matter 10 to 15 days time to matter, my lord, not to reach, my lord.
This PIL,
PL, my lord, matter.
PIL to you must come in next day, next
Right.
moment.
2 weeks time, my lord. The translation copy is already ready, my lord.
2 weeks time you want.
Yes, my lord, comply the office objection, my lord.
This is not for office of this.
Office objection, my lord. 7 office objection, my lord. One is court fee to be paid, my lord.
This application is filed seeking restoration of the writ petition which was dismissed for want of prosecution.
Dismiss non-prosecution, my lord, 14 to 23, my lord. Dismiss non-prosecution, IA to be filed, my lord. Recall, condone the delay to application file, my lord.
Ground of non-compliance of the office in order to enable the petitioner to contest this case on merits rather than being thrown out on technical ground. The application is allowed and writ petition is restored to its original file, which shall be listed for hearing on
Any date, my lord.
day after. On 3rd of April.
Office objection.
2 days time.
2 days, my lord. Translation, 7 office
No,
objection.
we'll.
1 week, 7 office translation of copy is ready, my lord. 1 week time, my lord.
My brother knows Kannada and English both.
Ready, my lord. Kannada English translation is ready, my lord. Compliance the office 1 week time, my lord.
No, yes, you are there. Entering the fray in between, yes.
But there are so voluminous, it is all ready, my lord. Kannada documents are ready. It is already translated. Only we are seeking permission to insert those translated copies.
Granted. All translated documents will be permitted to be inserted in on the record of the.
Please, ma'am.
Number 91, 92 and 93. Order, common order in separate order. The office of justice are dispensed with for the time being.
May I request,
Will
please?
be listed for admission hearing on, give some date.
May I,
15th week May or 21st week.
may I request, my lord? Serial number 50. My lord, we have already served the copies, my lord, statement of objection. I will file it in the office, my lord. Some date may be given next week or
Get the date,
Please,
Lord,
madam.
seal number 31 interim order may be extended.
31. All right, in 31, you have take 31 interim order to be extended, whosoever.
Yes.
We might not sit in the second half because of administrative.
You have a book.